What if I told you that for most of the last century, the world's most famous song was being held hostage? That singing happy birthday to you in a movie, on a TV show, or even in a restaurant could get you slapped with a bill for thousands of dollars from a very angry corporation. This whole tale has turned into a wild urban legend. Many folks think there's some old law in Florida that makes singing the birthday song in public totally illegal. It's a story about two school teachers, a corporate giant, a massive lawsuit, and a lie that millions of us just accepted as fact. This is what really happened. Let's start with a scene that is burned into our collective memory. You're at a chain restaurant, it's your friend's birthday, and you see them coming. A squadron of servers descends upon your table, not with that simple tune we all know, but with some bizarre high energy. Custom-written chant full of forced clapping. It's awkward, it's cringy, and it's the #1 reason this myth even exists. For years, people wondered, why can't they just sing the real song? It was such a simple question, right? The answer spread like wildfire. Oh, it's illegal. The song's copyrighted, and the restaurant could get sued big time. That tiny kernel of truth, the copyright spiraled into a massive urban legend. The story got bigger, weirder, and somehow, Florida became the villain. And let's be honest, it was an easy sell. Florida, our nation's chaotic petri dish of weird legislation, has a real on-the-books law that makes it illegal to sing in public while wearing a swimsuit. The happy birthday law might not be a real thing, but honestly, it totally feels believable, right? Let's mix that with the whole Florida man meme, and it screams Florida all the way. And just like that, the myth was born. Don't sing happy birthday in Florida, you'll do hard time. But to understand why that's a lie more fabricated than the enthusiasm in that restaurant birthday song, we have to go all the way back to the beginning. The story of Happy Birthday to You doesn't start in a corporate boardroom. It starts in a kindergarten classroom in Kentucky, way back in 1893. Two sisters, Mildred and Patty Hill, were teachers. Mildred was the composer, a talented pianist. Patty was a kindergarten principal and an expert in what makes little kids tick. Together, they wanted to write songs that were simple enough for young children to actually sing. One of those songs was called Good Morning to All. The melody was easy, catchy, and repetitive, perfect for 5-year-olds whose main hobbies were eating paste and taking naps. The lyrics were just as simple. Good morning to you, good morning to you, good morning, dear children, good morning to all. The song was a massive hit with the kids. It was so easy to adapt that the class would just swap out lyrics for any occasion. Happy journey to you, happy vacation to you, and as birthday parties became more of a thing, happy birthday to you. The new lyrics first appeared in a songbook in 1912 with no credit and no copyright. For years, the song belonged to everyone. It was the open source software of its day, passed around classrooms and parties, a piece of American folk culture meant for all of us. But that was about to change. For a couple of decades, Happy Birthday just spread organically. But by the 1930s, it was a certified celebrity. The song started popping up in Western Union singing telegrams and even on Broadway. This is when the third Hill sister, Jessica, saw this and decided to protect her family's creation. She sued the producers of a Broadway show for using the Good Morning to All melody without permission. Seeing this little family dispute, the Clayton F. Summy Company, which held the rights to the original melody, basically went, ooh, shiny, and saw a massive opportunity. In 1935, they swooped in and registered a copyright for Happy Birthday to You. This one piece of paper became the legal weapon they'd wield for the next 80 years. Over the decades, the Summy Company was bought and sold until 1988, when the copyright landed in the hands of a music giant, Warner Chappell Music, who paid an estimated $25 million for it. And Warner Chappell was not shy about cashing in. It claimed the song was protected until the year 2030 and started charging colossal licensing fees for any public performance. Want to use the song in a movie, a TV show, or a musical greeting card? You had to cough up the troll toll sometimes, hitting $700 just for a single use. Warner Chappell was raking in about $2 million a year from a kid's song. And you could feel the pressure all the way at TGI Fridays. And this, my friends, is how a legal threat from a giant corporation became a myth. We all told each other over buffalo wings. Restaurants, especially big national chains, are businesses. Using a copyrighted song in your dining room counts as a public performance, which puts a huge target on their backs for Warner Chappell's lawyers. So, the big bosses had a choice: pay a ton in fees, face a lawsuit, or just pick another tune. They happily went with option 3. Their marketing departments created those royalty-free birthday jingles we all know and tolerate. It was a purely business decision. But the public wasn't reading the legal memos. All we saw was the staff at Applebee's. Bless their hearts. Clapping off beat to a song that sounded like it was written by a marketing intern during a 3 a.m. energy drink bender. The logical conclusion for millions of us was that it must be illegal. The fear of a corporation's legal team was mistaken for the fear of breaking the law. And let's be crystal clear. Warner Chappell was never sending goons in trench coats to bust your 7-year-old's pizza party. That's a PR nightmare even they wouldn't touch. Your home and private parties were always considered fair use. They only cared about commercial use. But the damage was done. Myth was set in stone, reinforced every time we went out for a birthday dinner. It became a weird, fun fact that just felt true. The lie had become our reality. For decades, nobody really challenged Warner Chappell's claim. Everyone just paid up. But that all changed in 2013, when a filmmaker named Jennifer Nelson was making a documentary about the song's history. When Warner Chappell hit her with a $1,500 licensing fee, she basically said, absolutely not, and decided to fight back. She filed a lawsuit arguing that the song belonged to the public, not a corporation. Her lawyers started digging. They found old songbooks from the 1920s with the happy birthday lyrics printed without any valid copyright notice. But their smoking gun was the argument that the 1935 copyright Warner Chappell was waving around was completely misleading. They argued it only covered one specific, obscure piano arrangement of the song, not the melody or the lyrics themselves, which had been public property for years. The case dragged on for 2 years. Then, in September 2015, a federal judge dropped a bombshell. He ruled that Warner Chappell did not own a valid copyright to the happy birthday lyrics. After 80 years of raking in cash from just the piano tune of the world's most popular song, Warner Chappell finally settled for $14 million in 2016. Now, it's free for everyone. If you love watching strange myths get spectacularly debunked, do yourself a favor and hit that subscribe button. We unpack mysteries we all thought were true all the time, and you won't want to miss what we tackle next. Guess what? Since that 2015 ruling, Happy Birthday to You is totally in the public domain. You can sing, play, or perform it anywhere without any worries about lawsuits. Movies can use it, restaurants can sing it, and you can post a video of your family singing it terribly off-key without getting a copyright strike. The musical monster is dead. The whole myth boils down to this. We confused a scary letter from a corporate lawyer with an actual law. The threat was always a civil suit from a company protecting its investment, and that threat was only ever aimed at other businesses. The myth about a specific Florida law, it's just a myth, a perfect storm of a real copyright claim. Florida's quirky reputation and our own cringy experiences in restaurants, and the most hilarious part, even now, years after the song was freed, many of those chain restaurants still use their own custom songs. Why? Because at this point, those weird clap-happy jingles have become part of their brand. You've come to expect them. It's the last strange, cringy monument to a copyright that should have never existed in the first place. The story of the Happy Birthday Law is a perfect example of how the truth can get completely mangled. It started with 2 sisters writing a simple song for kids. It was hijacked by a corporation that made millions by convincing the world they owned something that belonged to all of us. And it created a lie so powerful it became a hard fact for generations. It's a story about corporate overreach and how copyright law can shape our culture in ways we don't even realize. But more than anything, it's a fantastic reminder that sometimes things we take for granted as being true are really just wild stories.